Namaskar. In this lesson, we shall try to understand the grievance redressal mechanism under the consumer law. It is said that where there is a right, there is a remedy. It holds good for the rights of consumers too. The consumers who were not recognized as a separate class till 1986 in India now have a number of rights guaranteed to them under the Consumer Protection Act 1986 and the recent Consumer Protection Act of 2019. Even prior to 1986 and in spite of the enactment of consumer laws, they enjoy many rights. In this lesson, we shall try to understand the grievance redressal mechanism in general and under the consumer laws in particular. The preamble to the Consumer Protection Act 1986 stated that the main aim of the legislation is to provide for better protection of interests of consumers. Under section 3 of the 1986 Act, it was provided that the provisions of this Act shall be in addition to and not in derogation of the provisions of any other law for the time being in force. In other words, the remedies under the Act are not provided exclusively under the consumer law. They are provided under general laws like the Competition Act, the Bureau of Indian Standards Act and other laws, and they are still available to the consumers to get their grievances redressed. Under the Consumer Protection Act 2019, under section 2 clause 9, consumer rights include the right to be protected against the marketing of goods, products or services which are hazardous to life and property, that is right to safety, the right to be informed about the quality, quantity, potency, purity, standard and price of goods, products or services as the case may be, so as to protect the consumer against unfair trade practices, that is the right to information, the right to be assured wherever possible access to a variety of goods, products or services at competitive prices, that is right to access to variety of goods, the right to be heard and to be assured that consumers' interest will receive due consideration at appropriate fora, that is right to be heard, the right to seek redressal against unfair trade practice or restrictive trade practice or unscrupulous exploitation of consumers, that is right to redressal, and the right to consumer awareness. Now, when we look at the mechanism to redress consumer grievances under the new Act, it can be seen that in order to redress the grievances relating to defect in goods, deficiency in services, product liability and misleading advertisements, a multi-layered redressal mechanism has been provided in the form of firstly the consumer protection councils, which are to be established at the central and state levels. They are required to render advice on promotion and protection of the consumers' rights under this Act under their respective jurisdictions. Secondly, Central Consumer Protection Authority, which has the mandate to regulate matters relating to violation of rights of consumers, unfair trade practices, and false or misleading advertisements which are prejudicial to the interests of public and consumers as a class. Their powers and functions are carried out by the Chief Commissioner and other commissioners. The investigation wing headed by a Director General and the District Collector by whatever name called, who on a complaint or on a reference made to him by the central authority or the Commissioner of a regional office has to inquire into or investigate complaints regarding violation of rights of consumers as a class on matters relating to violations of consumer rights, unfair trade practices, and false or misleading advertisements within his jurisdiction, and submit his report to the central authority or to the Commissioner of a regional office as the case may be. In other words, the District Collector also is empowered under the 2019 Act to look into the grievances of the consumers. Under section 17 of the Act, a complaint relating to violation of consumer rights or unfair trade practices or false or misleading advertisements which are prejudicial to the interests of consumers as a class may be forwarded either in writing or in electronic mode to any one of the authorities, namely the District Collector or the Commissioner of Regional Office or the central authority. Under section 18 of the Act, the central authority shall protect, promote and enforce the rights of consumers as a class and prevent violation of consumers' rights under this Act, prevent unfair trade practices and ensure that no person engages himself in unfair trade practices, ensure that no false or misleading advertisement is made of any goods or services which contravene the provisions of the Act or the rules or regulations made thereunder, ensure that no person takes part in the publication of any advertisement which is false or misleading. The central authority may, for any of the purposes mentioned above, inquire or cause an inquiry or investigation to be made into the violations of consumer rights or unfair trade practices either suo motu or on a complaint received or on the directions from the central government. File complaints before the District Commission, the State Commission or the National Commission as the case may be, intervene in any proceedings before the District Commission or the State Commission or the National Commission as the case may be in respect of any allegation of violation of consumer rights or unfair trade practices, review the matters relating to and factors inhibiting enjoyment of consumer rights, including safeguards provided for the protection of consumers under any other law for the time being in force, and recommend appropriate remedial measures for their effective implementation, recommend adoption of international covenants and best international practices on consumer rights to ensure effective enforcement of consumer rights, undertake and promote research in the field of consumer rights, spread and promote awareness on consumer rights, encourage non-governmental organizations and other institutions working in the field of consumer rights to cooperate and work with consumer protection agencies, mandate the use of unique and universal goods identifiers in such goods as may be necessary to prevent unfair trade practices and to protect consumers' interest. Further, the central authority is vested with the power to refer matter for investigation or to other concerned regulator, Director General of Investigation or District Collector, where the central authority is satisfied on the basis of investigation that there is sufficient evidence to show violation of consumer rights or unfair trade practice by a person, it may pass such order as may be necessary, including recalling of goods or withdrawal of services which are dangerous, hazardous or unsafe, reimbursement of the prices of goods or services so recalled to purchasers of such goods or services, and discontinuation of practices which are unfair and prejudicial to consumers' interest. However, the rule of fair hearing has to be followed while passing any of the above orders. Further, power is vested in the central authority to issue directions and penalties against false or misleading advertisements, to conduct searches and seizures as provided under the Code of Criminal Procedure 1973. Thus, it can be seen that the central authority has been established under the new Act as a super regulator with enormous powers to protect the rights of consumers and their interest. Under section 24, a person aggrieved by any order passed by the central authority under sections 20 and 21 may file an appeal to the National Commission within a period of 30 days from the date of receipt of such order. Now, coming to the consumer commissions. 3 multi-layered consumer commissions have been established under the 2019 Act to redress the grievance of consumers at the district level, state level and national level. Chapter 4 through sections 28 to 41, 42 to 52 and 53 to 70 deals with these commissions at the district, state and national level respectively. It may be recalled that under the old Act, there was a district forum which now is replaced by district commission. Let us have a look at the functioning of the District Consumer Disputes Redressal Commission, popularly known as the District Commission. The state government is required to establish such commission in each district consisting of a president and not less than 2 and not more than such number of members as may be prescribed in consultation with the central government. The district commission shall have jurisdiction to entertain complaints where the value of the goods or services paid as consideration does not exceed 1 crore rupees. A complaint shall be instituted in a district commission within the local limits of whose jurisdiction the opposite party or each of the opposite parties, where there are more than one at the time of institution of the complaint, ordinarily resides or carries on business or has a branch office or personally works for gain, or any of the opposite parties where there are more than one at the time of the institution of the complaint actually and voluntarily resides or carries on business or has branch office or personally works for gain, provided that in such case the permission of the district commission is given, or the cause of action wholly or in part arises, or the complainant resides or personally works for gain. Under section 37, at the first hearing of the complaint after its admission or at any later stage, if it appears to the District Commission that there exists elements of settlements which may be acceptable to the parties, except in such cases as may be prescribed, it may direct the parties to give in writing within 5 days consent to have their dispute settled by mediation in accordance with provisions of Chapter 5, where the parties agree for settlement by mediation and give their consent in writing. The District Commission shall, within 5 days of receipt of such consent, refer the matter in which complaint shall be made. Powers of the District Commission are laid down under section 39 of the Act, where the District Commission is satisfied that defect in goods or deficiency in services or any unfair trade practices or claims for compensation under product liability are proved, it shall issue an order to the opposite party directing him to do one or more of the following, namely, to remove the defect pointed out by the appropriate laboratory from the goods in question, to replace the goods with new goods of similar description which shall be free from any defect, to return to the complainant the price or, as the case may be, the charges paid by the complainant along with such interest on such price or charges as may be decided, to pay such amount as may be awarded by it as compensation to the consumer for any loss or injury suffered by the consumer due to the negligence of the opposite party, provided that the District Commission shall have the power to grant even punitive damages in such circumstances deemed fit, and also to pay such amount as may be awarded by it as compensation in a product liability action under Chapter 6, to remove the defects in goods or deficiencies in services in question, to discontinue the unfair trade practice or restrictive trade practice and not to repeat them, not to offer the hazardous or unsafe goods for sale, to withdraw the hazardous goods from being offered for sale, to cease manufacture of hazardous goods and to desist from offering services which are hazardous in nature, to pay such sum as may be determined by it if it is of the opinion that loss or injury has been suffered by a large number of consumers who are not identifiable conveniently, provided that the minimum amount of sum so payable shall not be less than 25% of the value of such defective goods sold or services provided, as the case may be, to such consumers. Again, to issue corrective advertisement to neutralize the effect of misleading advertisement at the cost of the opposite party responsible for issuing such misleading advertisement, to provide for adequate costs to parties and to cease and desist from issuing any misleading advertisement. Under section 40, the District Commission shall have the power to review any of the orders passed by it if there is an error apparent on the face of record, either of its own motion or on an application made by any of the parties within 30 days of such order. Under section 41, any person aggrieved by an order made by the District Commission may prefer an appeal against such order to the State Commission on the grounds of facts or law within a period of 45 days from the date of the order. Now, coming to the State Consumer Redressal Commission, popularly known as the State Commission, it has to be established by the state government and it shall ordinarily function at the state capital and perform its functions at such other places as the state government may notify. Further, regional benches also can be established by the state government. Each state commission should consist of a president and not less than 4 other members. The state commission shall have the jurisdiction to entertain complaints where the value of the goods or services paid as consideration exceeds rupees 1 crore, but does not exceed rupees 10 crore. Complaints against unfair contracts where the value of goods or services paid as consideration does not exceed 10 crore rupees. Appeals against the orders of any district commission within the state to call for the records and pass appropriate orders in any consumer dispute which is pending before or has been decided by any district commission within the state. The state commission therefore, at any stage of the proceedings, transfer any complaint pending before the district commission to another district commission within the state if the interest of justice so requires. The state commission has the power to review any of the orders passed by it, again on the ground that there is an error apparent on the face of the record, either on its own or when applied for by any of the parties within 30 days from such order. Any person aggrieved by an order made by the state commission may prefer an appeal against such order to the national commission within a period of 30 days from the date of the order. No appeal by the person who is required to pay any amount in terms of an order of the state commission shall be entertained by the national commission unless the appellant has deposited 50% of that amount. Now, coming to the National Consumer Disputes Redressal Commission, popularly known as the National Commission. It is established by the central government. It ordinarily functions at the national capital region. It consists of a president and not less than 4 and not more than such other number of members fixed by the government. The National Commission shall have jurisdiction to entertain complaints where the value of the goods or services paid as consideration exceeds rupees 10 crore, complaints against unfair contracts where the value of goods or services paid as consideration exceeds 10 crore rupees, appeals against the orders of any state commission, appeals against the orders of the central authority, and to call for the records and pass appropriate orders in any consumer dispute which is pending before or has been decided by any state commission where it appears to the national commission that such state commission has exercised a jurisdiction not vested in it by law or has failed to exercise the jurisdiction so vested or has acted in the exercise of its jurisdiction illegally or with material irregularity. It is said that law helps those who are vigilant and not those sleeping over their rights. The same principle is squarely applicable to the consumers as well. There is a limitation period for initiating consumer complaints before any of the fora which are mentioned in the preceding paragraphs. The district commission, the state commission or the national commission shall not admit a complaint unless it is filed within 2 years from the date on which the cause of action has arisen. So, 2 years period is the limitation period during which the consumer complaint has to be lodged generally, though the delay, if any, may be condoned for justifiable reasons. Now, coming to the conclusion. Dear students, from the foregoing discussion, it becomes clear that the new Act has provided a clear and well established mechanism to redress the grievances of consumers, not only through the adversarial, but also through the ADR mechanism, more particularly through the process of mediation. Resolution of consumer disputes through the process of mediation, as referred by the various consumer commissions, have been dealt with in a separate lesson. I sincerely hope that all of you have enjoyed listening to this lesson, which is important from the viewpoint of enforcement mechanism relating to consumer rights. We shall meet in the next lesson. Thank you.